It is March 19th, 2026, and this is the Court Gallery. Welcome, ladies and gentlemen. I have a packed compilation for you today that really highlights the shocking situations heard from the bench. You're going to see a 94-year-old defendant who literally forces the judge to leave his seat to be heard, a high-stakes DUI argument over a hidden medical condition that leaves judge absolutely fuming, and a neighborhood feud where a defendant, one we've possibly seen before, openly admits to using his car as a weapon for payback. The excuses are wild. The judicial reactions are even more intense. And ladies and gentlemen, I want you to get your drinks, buckle up, because it all starts right now.
My second matter, Your Honor, is Jennifer Anderson. It's case 4A ending in 696. And I have heard from my client. I received an email from her yesterday indicating that she knew about this court date. I'm very surprised she's not here. I would ask the court to entertain noting the FTA and setting it over 1 week. That's it. Thank you.
I'm not going to do that, Mr. Wallace, and the only reason I'm saying that is the last time that Ms. Anderson went on warrant status, it was August of 2024. She didn't return to court. She never returned to court voluntarily. She was picked up the last time that she appeared, which was the court date on, let's see. She appeared in December. Yeah, she appeared for the first time then in December of 2025, was set over to today's date, March 19th. I'm going to find that Ms. Anderson has failed to appear. I'm going to authorize a warrant in the standard amount.
Understood. Thank you, Your Honor.
Thank you.
Jennifer Anderson.
Jennifer Anderson, if I could have you unmute and turn your camera on, please. Jennifer Anderson. You know what her file is?
I don't.
I'd issued a warrant on the case.
Oh.
I'm here.
All right, ma'am, hang tight just a sec. We issued a warrant on your case, so we just need to get the file back. So it looks like, Ms. Anderson, what's taking place today is your charge is being amended from a theft in the 3rd degree to a charge of criminal trespass in the 1st degree. In entering that plea today, first of all, have you had sufficient time to discuss your case with Mr. Wallace?
Yes.
Need any additional time?
No.
Jennifer Anderson, you are 30 and you've completed the 12th grade. Is that correct?
Yes.
Able to read and understand the English language.
Yes.
In entering a plea today, you're giving up some important rights that we're going to review on the record. You have the right to a speedy and public trial by an impartial jury in the county where the crime is alleged to have been committed. You have the right to remain silent before and during trial and the right to refuse to testify against yourself. You have the right at trial to hear and question the witnesses who testify against you. You have the right at trial to testify and have witnesses testify for you, and witnesses can be made to appear at no expense to you. You're presumed innocent unless the charge is proven beyond a reasonable doubt or you enter a plea of guilty. And you have the right to appeal a finding of guilt after trial. You understand those rights, Ms. Anderson?
Yeah.
You understand that in pleading guilty today, you're waiving or giving up those rights?
Yes. Stop.
Charges you are pleading to today is a gross misdemeanor. It's subject to 364 days in jail and a $5,000 fine. There has been a pretrial agreement made. Do you understand the court does not have to follow anyone's recommendation as to sentence, but can sentence to the maximum authorized by law? Court can place you on probation for 2 years, during which time you pay cost, fees, and assessments as authorized by law. To the charge of criminal trespass in the first degree taking place on June 12th, 2024 in the city of Battle Ground, Washington. How do you plead?
Guilty.
Are you entering the plea freely and voluntarily?
Yes.
Anyone made any threats or promises to get you to plead guilty?
No.
The factual basis states on June 12th, 2024 in Battle Ground, Washington, I remained unlawfully in a building. Is that a correct statement?
Yes.
To accept the plea, I'll find it knowing, intelligent, and voluntarily made after advice of rights and advice of counsel. Go ahead, Mr. Wallace.
Thank you, Your Honor. Earlier, the court indicated that Ms. Anderson had been picked up on a warrant, so we'd ask that the jail calculate any credit for time served. Otherwise, we'd ask the court to please follow the recommendation. It's been negotiated between the prosecution and defense. From a financial perspective, Ms. Anderson is not working and is caring for a young child. We ask the court to waive any discretionary fines or fees. Thank you.
Anything you'd like the court to know, Ms. Anderson?
No, not at the moment, I guess.
Yes, criminal trespass in the first degree. So on cause number 4A0569696, count 1, 364 days in jail with 361 days suspended, 3 days to serve on work crew. Certainly, if there is credit, or for Ms. Anderson being previously held on this matter, credit will be granted towards the work crew time. It'll be a $5,000 fine with all 5,000 suspended. I will fine pursuant the Blazina analysis that Ms. Anderson is indigent. 24 months of bench probation. No law violations. She will complete a theft awareness class. Ms. Anderson, we're going to set a mandatory review date, ma'am, that is going to be on Thursday, June 18th, 2026 at 1:30. At that time, I'll be looking at your progress with the 3 days of work crew and the theft awareness class.
Okay.
We're going to be sending you some documents regarding the proceedings today. Are you still getting your mail at the address on 2nd Avenue in Battleground?
Yes.
All right, we'll send documents there, ma'am. If there's nothing further, you can log out. Thank you.
Thank you.
Thank you, Your Honor.
Thank you, Mr. Wallace.
Yeah, bud.
All right, Mr. Johnson, can you hear the court? Can you hear the court?
Yeah.
Okay. You are 94 years old, is that correct? Are you 94 years old?
Yeah.
And how many grades in school did you complete?
Pardon?
How many grades in school did you complete?
How many?
Yeah. We're going to have to get him some audio assistance. We're not going to be able to vocally if he can't hear what we're
Put
doing.
this on and see if it makes it easier for you to hear the judge. Just wear that over your hold it up to your ear. I know you have hearing aids. Leave your hearing aid in and put that by your ear.
Okay, Mr. Johnson, can you hear me?
Yeah.
Okay. And how many grades in school did you complete?
How many days?
How many grades in school did you complete?
I did. What was it?
How many years of school did you complete?
How many?
How many years of school did you complete?
How many?
How many years of school did you complete?
Oh. 9.
Okay.
The last year was when I was in the service.
Understand. Thank you.
Yeah.
I have some real concerns about doing a plea.
And Your Honor,
And I'm not saying that there's a good solution or anything like that. I just don't know what we should do.
I'm open to suggestions, Your Honor. What I can say is that I've had an in-person meeting with Mr. Johnson. It would have been the date of our last meeting. I can look and see when that is. For the record, I think Two Watch Monitoring reached out to the court and has expressed that he has been degrading over time. He's very aged. At the time that we did the plea statement in my office in person, he was able to communicate. It is difficult, as that would be reasonable to assume based off the age. I wonder, Your Honor, and this is not, I think, necessarily usual, but I feel like he hears better if he's spoken to directly from very close, where he can also see the lips. If Your Honor would be willing to sit next to the table, I think that might help. And if we continue to have concerns, I mean, I can file a 1077, but I just don't know that's necessarily. I don't have concerns about his competence today, but they may come up, frankly.
Any objection to me going down there and
No objection, Your Honor. No.
Okay. Give that a try.
Oh, are you going to go over there too, Ryan, so we can hear your recommendation? Yeah.
Here, this mic, Johnson. It's going to be how we record, okay? All right. Can you hear me?
Yeah.
So it looks to me like you're doing a change of plea today. Is that correct? You're going to enter a guilty plea today?
Yeah. I
Yeah.
learned a lesson. Big.
You learned a lesson big. Have you had plenty of time to talk to your attorney, Mr. Campbell?
Yeah. Yeah.
And do you need any additional time to speak to him?
Yeah.
Do you need to talk to him about anything else, or are you good to go today?
I don't think.
Okay, that's fair.
Yeah.
So you're entering a plea to a charge called assault in the fourth degree with sexual motivation. Okay. And entering a plea today, you're giving up some rights that you and I are going to talk about. Okay.
Yeah.
You have the right to a speedy and public trial by an impartial jury in the county where the crime is alleged to have been committed. You have the right to remain silent before and during trial, the right to refuse to testify against yourself. You have the right at trial to have witnesses called and to call witnesses on your behalf, and witnesses can be made to appear at no expense to you. You're presumed innocent unless the charge is proven beyond a reasonable doubt or you enter a plea of guilty. And if you're found guilty, you have the right to appeal after trial. Do you understand all those rights, Mr. Johnson?
Yeah.
And do you understand that in pleading guilty today, you're giving up those rights? You're waiving those rights.
I understand.
Okay. Charge which you are pleading to is what is called gross misdemeanor. It is subject to 364 days in jail and a $5,000 fine. Okay.
Yeah.
That's the maximum.
Yeah.
Okay.
I would never.
No, we're just making sure you understand the maximum.
Oh, okay.
Okay.
Yeah.
There's a pretrial agreement, which is this document right here. Do you understand that court does not have to follow anyone's recommendation as to sentence, but can sentence you up to the maximum authorized by law? I need to have you answer out loud because we're recording.
Yeah.
Okay. You understand the court can place you on probation for a term of 2 years, during which time the court could have you do things and pay fines, fees, and costs and those sort of things. Okay. If there was any damages to anyone, you pay also what's called restitution. Okay. To the charge of assault in the fourth degree with sexual motivation taking place on September 4th, 2025 in the city of Battleground, how do you plead?
Yeah.
Are you entering the plea freely and voluntarily? Are you entering the plea freely and voluntarily?
Yeah,
Has anyone made any threats or promises to get you to plead guilty?
yeah,
Section Y here, Mr. Campbell's DNA sample. That one.
I believe I would have to look at the case to be confident, but if I check that, I went over the advisement, and I believe that time that they required. Now the client does have prior felony history, but it's dated, so I don't know if he has.
Okay.
Was
already done. You're entering the plea freely and voluntarily. Has anyone made any threats or promises to get you to plead guilty?
no,
The factual basis states on September 4th, 2025, in the city of Battleground, Washington, I did intentionally wrote. Yeah.
On or about September 4th, 2025, in the city of Battleground, Washington, I did intentionally touch an unknown woman's breast, Amanda Kelly, in a fashion a reasonable person would find offensive for my own sexual gratification.
Is that a correct statement, sir?
yeah,
I will accept the plea. I'll find it knowing, intelligent, and voluntarily made after advice of rights and advice of counsel. Go ahead, Mr. Campbell.
Your Honor, sometimes in the legal system, we're met with a problem that really is not set up for any kind of good resolution. This is where we're at. Evan Johnson was charged somewhat recently before this case and resolved a case of an exact similar nature. And in most situations, what I want to be clear about, the defense is free to argue, and I believe the pretrial agreement outlines what the date for the city's position is about the resolution. But defense is not asking for any jail to be imposed. That's an exceptional request in any way, because Mr. Johnson's behavior that he's taking responsibility for is very significant. Victims, I'm not sure if we have victim input, but can reasonably be assumed to have been very upset by this fact. Mr. Johnson has passed a sex crime history as well, which is a negative fact. I asked Mr. Johnson to go and talk to his doctor about what jail would look like. And Mr. Johnson has been fair with me that basically he believes he will die. And I think there's a strong reason that's true. I'm not saying that to leverage your honor in any way, and bringing what is an apparent issue. If we put him into jail, that could be a result. I don't believe that the jail has a really good means of not because of a lack of desire to, because of a lack of an ability. He lives at home. He rarely goes out. When he does, at times, he engages in behavior that is not acceptable. And he's been on electronic home monitoring for an extended period of time pre-trial in this case. So he does, in my opinion, have day-for-day credit as related to his sentence. I did not get the case law on that, but I believe because of the pre-trial electronic home monitoring, because he was actually kept in his home, Washington State provides him day-for-day credit. So I believe in the sentence we would request that whatever amount of time he served on electronic monitoring, that also takes out part of the 304-day potential sentence on the new case. There's a bunch of suspended time on the probationary matter, so I have that into account. There is time for your honor to send him to jail without. I do think that there are great risks in his health if he does that. I think if we keep on electronic home monitoring on one case, and maybe that's the probation matter, you can do that. But what I want to be clear about is he's not really doing electronic home monitoring. Because the two-eye monitoring said, I'm afraid if he comes here that he's going to die while house liability. Can't do it. And they noted that his physical abilities have degraded. The first time I met him, about 2 years ago to now, that's true. And I can tell you, I've had numerous participants who are here in court come up out of their chairs to try and come and make sure that Mr. Johnson doesn't fall on the ground. If he goes to the jail, I think he's a great fall. So we're asking your honor ultimately for a sentence commensurate in electronic home monitoring at all time. You could be sent to jail on probation violation of that. I think that the electronic home monitoring provision is not necessarily appropriate in this instance, but I do understand if your honor imposed it. I have fears about him having to go to 2 auctions and drive. I have fears about all of that. Probably needs placement assistance with adult protective services. I know the prosecutor is asking that he be directed by recommendation. Yes. But to be frank with you, with his criminal history, I don't know if there's a home place for adult family home that's available. And so I leave your honor with very difficult options. There's a victim in this situation, and I want to be clear. The community is also, I think, somewhat of a case, but the resolutions from a jury perspective, I mean, for your honor, are just very different. Mr. Johnson's behavior is unacceptable. He's told me that functionally his sexual organs don't work, which is still not prohibitive of him making behavior that is sexual in nature and that is dangerous to women in the community. But he's a 94-year-old man that I guess I'll just leave my so much information that asking me to impose significant EHM sentence. It's spend the time on probation matters and not through that. Big risk. Yeah.
Thank you, Your Honor. The city understands all of this case. Unfortunately, I look at this and I don't necessarily disagree with Mr. Campbell regarding the jail. Unfortunately, I'm not have a lot of options. Campbell's indicated watch about ability to comply with EHM. There's been a number of violations that follow these violations on, but it's pretty consistent. Very difficult, but not fine. His history is very recurring. It's not the age issue. Have a 1993 molestation. Yeah, and then there's significant 3 years of time without any additional. So I don't want to say this is an ongoing problem for the last 30 years, but we have someone who has demonstrated in earlier life now repeatedly in his older age, inability or an unwillingness to support himself appropriately, and frankly, as both instances, day, he somewhat used his age as a lure to bring these victims in to get himself. It's hard for the city to not see significant consequence because it appears the city's naive the threat gone. Mr. Johnson continues to go to the store where he's engaged at a notice from too much monitoring just last weekend. Well, that's where this incident occurred. Prior one was at Fred Meyer. While he's on EHM, there's no option to be able to go to groceries. But at least maybe if there's some kind of eyes on, he will feel more pressure not to engage this problem behavior. With regard to
What would you define? I'm not saying that to be flippant. I'm
no,
just trying to
his
mine all of our options.
I'm having EHM where in your over. You have noticed at least there's going to be notice. Frankly, after thinking about this case, I do believe that APS is probably a good option. That would be the city push. I understand Mr. Campbell's point with the history. I don't know. The nature of the charges don't lend themselves to community court, but oversight through that. Maybe appropriate to on a probationary community court. I understand the difficulties, but the city can't ignore the danger to the community and the seriousness of the victims. Victim in this case. And we have
Is there any victim feedback? I mean, I can. One of those times where I think we can all sit here and not come up probably with a workable option. My concern for Mr. Johnson, very frank, not going to die in custody. It is that he's going to be an immense burden to the Clark County Jail or Mania County or wherever he's incarcerated, trying to just manage, get him to and from the bathroom, get him to and from meal, get him to and from wherever he needs to go, protect him from other prisoners, help protect other prisoners from him. I don't know. I mean, so many times we don't see what the problem is, send someone or reincarcerate someone, and then we're getting the notices back. So-and-so's got a bad back. So-and-so has this persistent issue that we can't deal with. I mean, this is one that he's going to show up there day one at 94 years old, hard of hearing with a walk. And they're going to say, what on earth are you doing? Right? The jail is not going to, as much as we think that is the remedy, incarcerating him for 94 days. I don't know if they will keep him for 94 minutes if I assign him to jail. It's just not going to work. And if it does work, it's going to endanger other people because Mr. Johnson is going to need full-time supervision with an already taxed system at the jail. Like we're just like lighting a fire in a different spot if we do that. I'm also not going to put him in community court. I'm not going to avail our community court staff or our clerks to the risk of having to encounter Mr. Johnson and getting fondled or touched or whatever else. That would be stupid on my part because I would be taking my own court staff and hoping that something doesn't happen, hoping that he's able to control his impulses, where he's demonstrated over time he doesn't control his impulses. So I'm not going to do that. It sounds like EHM will continue to have him. I understand they don't want to have him. I understand he's degrading, but I think that the circumstance is that we place him on EHM. My thought at this time is, credit or not, I have 90 days of jurisdiction. Put it on the old case, I can put it on the new case. My thought is that I have a once a month check-in where either I review the documents or we have Mr. Johnson back into court, which I know is also a logistical nightmare, to determine if he's compliant. There's not a long-term solution. I don't see anything where the next several years I can keep my thumb on Mr. Johnson. That said, he's not done horribly on release with the HM, other than going on a little foray every once in a while. You are not to go to Fred Meyers. if it's not already clear to you. You are not to go to Albertsons if it's not already clear to you. And goodness, if you can have somebody else go to the store for you, have them do it. This is not working. Whatever impulse you have or lack of impulse control you have, being in society with females is not working for you. And I'm sorry if you're lonely, but you're cutting yourself off by your decisions and actions in the community. The community is saying we don't know what to do with you. Can't incarcerate you. I'm not putting you in community court and endangering my staff. I'm going to put you in your home on EHM and pray that you don't go out and do this again. Because if you do this again, you will die in the Clark County jail. I have more than enough jurisdiction to lock you up for the rest of your life. And if you need a motivation to rein in whatever makes you want to do these sort of things, think of that. I know you will die in the jail if you do this again. I will not hesitate without bail to incarcerate you. Do you understand?
I understand.
Okay, well, I thought you understood in 2024, but you better darn well understand now. All right, so here's what we're going to do. I do not want to create an issue with whether he gets credit or not credit. I'm going to impose 90 additional days on home monitoring. I am not going to do any kind of calculation at this time. It looks to me that he initially appeared on the 11th of September, 2025. It looks to me that that is 170 days. He's already been on EHM. Well done, Ms. Landwehr. Okay. I think that's what we'll do. Okay. So on the new charge, cause number 5A 0767480, 364 days in jail, with 274 suspended, leaving 90 days to serve on electronic home monitoring. Will be a $5,000 fine with all 5,000 suspended. Whatever resources Mr. Johnson has, and using it, continue to pay for his EHM. No law violations, bench probation for 24 months. No contact with Albertsons stores. And I'm assuming no contact as well with Manchester. You're going to get a copy of this document, sir, where you can't contact the individual. Yeah, the pretrial NCO is now going into a post-conviction NCO. Psychosexual evaluation.
I do have information that you included one review his age. Yeah, I would ask you, Your Honor, not impose it. Financial investment around.
It's fine. I'm not going to do it. No contact with Albertsons stores. I'm going to set a review date. I'm going to. Do we have a phone number for them? I'm just thinking on the plea form. To review Mr. Johnson's case in 1 month, Madam Clerk, I have no calendar. Can you give me our closest date after? To review Mr. Johnson's case on the 23rd of April, 2026, 1:30. My thought is that right before that date, he's in compliance with EHM. I'll strike the court date. I'm not going to try to make him come in necessarily. Well, Mr. Johnson, your next court date is going to be April 23rd, 2026 at 1:30. And we'll give you a call a little bit before then if we can strike that court date, okay? And I'm gonna see you every 30 days to make sure that you're doing what you're supposed to do. On the probation. Okay, for Mr. Johnson's 470 days PHM credit time served. To review that case as well, our April
Telephones don't get along very.
Yeah.
I-
No, that's
I
fine.
hit wrong button.
So you're saying, how do I let him know if you have not come to court?
Well, and yeah, the problem with 2-watch monitoring has been they ask to stop. Usually the process of the office, by a calendar, and that tells us 2-watch monitoring folks for that.
Well,
2-watch monitoring acts. They ask him to stop doing that. They ask the court to authorize that all, but then he has a within a bill to tell them. So, make phone call. That's how. I don't know. I didn't understand the protocol. Areas. The on the wrong days. Well, so that's the issue is that lack of.
I think it's most simple. Continues on EHM. Excuse me once.
The only alternative. I've been having my investigator try to go out the house, and there's been some bit that. Could also send a notice, rest, well, court filing.
No, it's on his.
And you gotta come back next month.
that,
Here.
yeah.
Okay.
Yeah,
Just my recommendation, the questions for the first I can talk about.
okay. Well, just,
Yeah, I'll talk to you about stuff. Right now we're on the record.
yeah,
Okay. The maybe for the trial, no contact order, termination order.
Gotcha. Thank you.
Excellent.
Mr. Bologna,
Good afternoon, Your Honor. Anthony Bologna, Bennett City Judge.
so I'm not gonna make an issue of it. Your motion was filed yesterday. You can respond verbally, Mr. Bologna,
I
okay?
appreciate that, yeah.
Okay, go ahead.
So we received the motion yesterday. And then our response would be that,
Well, wait, let him argue first.
go for it.
Go ahead.
Let me go first.
Yeah.
Okay, my motion. All right, thank you, Judge. I think it's self-explanatory, the motion. I believe it's right on point respectfully. We want the court rule says about the interest of justice prior to sentencing, about a motion if the plea itself was not defective by the court or by the attorneys, which we're not challenging. We're saying the interest of justice is the standard by court rule. And that is, it's almost, I wish all my cases were so clear cut, at least in my opinion. And that is if somebody is a diabetic and the law and the science is crystal clear that taking a breathalyzer is just not accurate. In fact, the officers are informed on their sheets that if somebody's a diabetic, not to give to get blood. And also the statute, I don't have it right this second, but I could have it in a second. That the only is blood and urine is permitted, obtaining a reading for blood alcohol content when somebody has diabetes. And it's crystal clear my client has diabetes. We have all the medical records for that. I didn't, I almost said sealed. I didn't want to provide those to the court. He can swear to it. His doctor has a letter that says that he's a diabetic. In fact, the letter says that it can cause artificial highs, not negatives, but positives, in taking any type of a breathalyzer reading. And that's why it's blood only. So Your Honor, I don't fault the officers. Of course, they gave a breathalyzer. But in the interest of justice, you know, this is an very important case for my client, like it would be for anyone. And he's a medical doctor, and licensing to that. And so, you know, it was a 0.09 and a 0.10. And if it was artificially high, what was his real blood alcohol level? 0.02, 0.03, 0.04 maybe, and it's artificially high. So in the interest of justice, and Judge, I've been 40 years, but however long the court's been on the bench, I presume about 30, is that I've never brought a motion like this in this building. And so I truly believe that we have good cause in the interest of justice by the statute or by the court rule, that it would be not fair to set it aside prior to the sentencing and allow him to proceed to trial. In the event the judge was Your Honor was kind enough, for lack of a better word, to set it aside and set a trial, that would be a for sure trial date that will go. I don't expect it to be any more at all than a one-day trial. Thank you.
Mr. Bologna?
Thank you, Your Honor. Yes, I received the motion yesterday afternoon. Thank you for allowing me to respond orally. We were here, Your Honor, as we would call, spent quite a lot of time trying to resolve this matter. We came to what we felt was a good resolution ultimately in this case. The plea was taken. The officer was here on that date. That officer is no longer, that officer is no longer a Trenton officer. So we had a subpoena to get him in here. We were ready to proceed for trial on that date. And we thought we had a resolution reached. As far as the whole argument regarding diabetes, it's a fact issue. I believe the officer, likely being the officer that it was in this case, probably asked if you have any medical conditions prior to administering anything. All that said, Your Honor, will ultimately reach the court's discretion, but the city was prepared to go on trial or to go to trial on the date that it was actually set. So that's our position on it.
Your Honor, let me just, quick reply. And that is, my client has never advised against the attorney. Unfortunately, I don't think practice that area of the law, at least beyond pleas. That is very important, and it's instrumental and material in giving a breathalyzer that if you have diabetes, then the acetones, and I put a little bit more of the scientific terms in the motion. Thank you, Your Honor.
Anything else, Mr. Bologna?
Better.
Except as provided, this is under 6310B. Withdrawal after acceptance, but before sentencing. Except as provided in subsection 3 after acceptance, but before sentencing. A plea may be withdrawn on the defendant's motion or with the defendant's consent only in the interest of justice. It may not be withdrawn. A withdrawal of the plea would substantially prejudice the prosecutor because of reliance on the plea. I don't know that it would substantially prejudice the prosecutor, but I can't find that this is in the interest of justice. As Mr. Bologna pointed out, there were lengthy discussions that occurred on the date of the trial. There were numerous pre-trials. I remembered when you said sidebar, Mr. Kolovis, when you were here for sentencing, that this was based upon the fact that primarily that this was based upon the fact that he was a diabetic.
Correct.
I had read the report, which I never do. I'd read the police report, which I never do before there's a conviction on it. I'd read it the date of the sentence, which I always do when I'm going to sentence somebody. And if you look at the report, it says, Pastor informed me he did not suffer from any injuries other than some back pain. He denied being a diabetic. He stated that he had no recent head injuries. He stated that his highest level of education obtained was a master's degree. He informed me he could understand everything that I was saying. So while your client is now advancing this argument, or you are, I suppose, on behalf of him, The police report clearly indicates that he told them that he was not diabetic. I'm sorry, I'm going to deny your motion.
Your Honor, just if I may, just for the record, just make a record. And Your Honor, he did not say that. And it's on his listing of his medication. And there's a letter from his doctor talking about
I
it.
don't know how they're supposed to be mind readers.
But even if they,
Listen.
nobody says they are, nobody says they did anything wrong. I'm
It
just saying.
says he
the interest of
denied,
justice.
he denied being a diabetic.
And that doesn't mean the results.
That means that they might have taken other steps. And this is a decision I'm not gonna reverse myself on. I've thought about this. The interest of justice do not require setting aside the plea. I will be happy to let you appeal this. I will sentence him. You can file your motion to stay any punitive measures pending the appeal. I'll be happy to do that for you.
You don't judge, what if somebody is raped and they're serving 50 years in the DNA contact? The person said, I'm
Mr.
guilty.
Clovis, I heard you. I made my decision.
Doing my talking, all right.
Do you want to sentence now? You ready for sentencing?
Your Honor, I would ask this, may we be allowed to do an interlocutory appeal?
No,
immediately?
I'm going to sentence.
You want a sentence?
Yeah, you can take your appeal and you can do, I will stay whatever's punitive.
I appreciate that, Judge. I suppose, go ahead and,
Okay,
with sentencing.
all right. So have you had a chance to review the report with him? And are there any material additions, corrections, or deletions?
If I may have.
Sure.
No? Yeah. Go ahead. I understand your prescription.
Listen, Mr. Pastor,
Yes.
you guys can take an appeal. I'm not trying to jam anybody here. You told the police, according to the report, you denied being a diabetic. I don't know what they're supposed to do. Now even the police officer is lying in a police report, which listen, I'm not going to listen to this anymore. I made my decision. Nobody has ever heard me say I'm always right. Not one person's ever heard me say that. I'm moving on. We're going to sentence. And then you can take your appeal. I have no issue with that.
Thank you, Judge.
All right, is everything in this report accurate?
Yes, Your Honor.
Any material
Nothing
additions?
you have to leave.
Okay. Anything you would like to say on his behalf?
Your client, my client is a medical doctor. Medical profession, and he runs several offices with his wife, who's a medical doctor. He denies, and I understand the plea of guilty to appear, but given the other circumstances now that he relied upon, he denies that, he was under the influence that day. Thank you, Your Honor. Nothing further.
Sir, anything that you would like to say before I sentence you?
I have been prescribed that for me, best year and a half. Got all my prescription. Nobody has ever asked me. I do not recall the officer has asked me. I'm not diabetic or not.
Can I see your AA attendance?
Like in the park.
Pardon?
And
He may have it in the car. Do you want him to go to the car?
Do you have them in the car? Have you been going twice a week?
yes, I will here. I got it. Did I continue to be able to?
May he go to his vehicle, Your Honor?
Sure.
3 minutes.
Sure.
I think you want to run out there and go get it. I'll reach back. You'll pass.
I'll tell you what. Come on back up here. Let's just finish the sentence. You give them the probation afterward, okay?
Okay, got it.
All right. Anything else, Mr. Pastor?
No, I'm not sure if any of my medical letters was being presented and presented properly. And that was one of my main concern because of the fasting, my ketone levels and anxiety, and I haven't prescribed 1,000 milligrams of metformin. I got my prescription history for the last 2 years. I just emailed that to Mr. Gross. I haven't prescribed for diabetic medications, but I take every single day because my weight went up to almost 200 pounds after the.
I know, but you're not going to argue with me about my decision.
That's not my intention. And I wish this would have came to resolution way sooner. And our previous council would have presented this facts as well too, which I'm just coming aware of it. Is not none of this was being really properly presented. And I'm very disappointed about that because that should have been presented properly in a timely fashion. That was not my intention whatsoever to take this to this far out of context. That was absolutely not my intention. It was not my intention. I asked him to present the facts properly a number of times, and it has not taken place.
I don't know I didn't see anything that your lawyer did wrong. You didn't see anything your lawyer did. Listen to me. I don't want to quarrel with you. You denied that you were a diabetic according to the police report. Now, if somebody tells somebody that they're not a diabetic, I don't know how they can raise the defense that, yes, he really is a diabetic. He was just kidding, and they should have taken different procedures. Now, I don't want to dispute this with you anymore. I've had this feeling the whole time, Mr. Pastor, that you don't think you did anything wrong. You really don't. And you had one 4 years ago, and you're only what, 46? You get one in the next 50 years. That's a felony.
We're not getting one.
Well, I know, but nobody thought you'd probably be back the second time either.
It was not my intention.
Mr. Pastor, let me finish. It's my turn to talk. If you have something else you want to tell me before I sentence you, I will be more than happy to listen, but I'm not going to go back and talk about your lawyer. I don't see what he did wrong. If you have something else you want to say that's going to cause me to be lenient, I'll be glad to listen, but please. Do you want to say anything else?
I'm not here to do anyone. He's such a nice guy.
I don't want to talk about Mr. Zelnick.
Of course. I do not recall the officer asked me if I'm diabetic. I'm taking diabetic medication every single day. I missed it on my medication sheet. I'm taking diabetic medications. I told him precisely every single day I'm taking 1,000 milligrams. It's the highest milligram of metformin you can take. That's for type 2 diabetes. I mean, literally, I was getting heart disease. If I don't take that medication, I sent him, show him my
Mr. Pastor.
He's passed that right now, the judge.
And,
Not going to upset the judge.
and you can appeal this. I've never, like I just told your lawyer,
to upset you.
you're not upsetting me, but I'm not going to allow people to argue with me after I've made my decision. You see that guy on the wall right now? Look at that guy. That was my father. You know what he told me when I graduated law school? Don't argue with the judge after they've made their decision. There were 3 things. That was one of them. I didn't then, and I'm not going to let people do it now.
Not my intention, Lord.
12 months probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. Creative and poppy seeds and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. You're to submit to chemical testing, PVTs, and ETGs bi-week. You're to attend AA twice a week until in treatment. Once you get an outpatient treatment, you no longer have to go to AA or NA. You're also to attend the Victims Impact Panel. 5 days jail credit, 1 served 4. I'll let you serve those as follows. 2 days on the court work program. Those have to be completed by May the 1st. I'm sorry, 2 days court work program. They'll schedule on those, and 2 days of community service by May the 1. Fines $300, costs $300, 75 victims' rights fee, $50 justice assessment. That is 7 1/4. Screening fees $60 for 785. Probation fees are $240 for 1,025. You have cost of recovery of $150 for 1,175 plus $70 in court work program fees, $1,245. You may be eligible for early discharge. If you complete all this in 6 months, you can apply. If you violate, your probation could be revoked. You could be incarcerated for up to 93 days with credit for 1 day served. You have 21 days to appeal and 14 days to apply for a court-appointed lawyer. Now, what I'm going to do, Mr. Kolovas,
Yes.
I'm going to indicate on here defendant need not report. And will you tell probation this, Amy? Need not report. Well, look, I'm prepared. I'm prepared. If you appeal, you file a motion with me, and I'll make his fines due on May the 10th. But he's going to you can file a motion, and I will stay anything that's punitive. I'll stay which I don't consider to be AA, outpatient victims impact panel. I do consider it to be court work program, community service, or payment of fines.
Okay, thank you, Judge.
So you can file a motion when you appeal, and I'll be more than happy to stay anything that's punitive, but you got to come in front of me and we'll figure everything out. Okay.
Consider it, Judge. Thank you.
And then he's going to go meet still with probation because I do need him to test. I want him to test bi-weekly. Okay.
Yeah.
And I won't make your money due until May 10th. And if when we come back, I presume he's going to file this real soon.
For next week.
I will be happy to extend the time period to pay and to indicate he doesn't have to do court work or community service until after the appeal is exhausted.
That's very kind of you. I appreciate your
Okay.
time today
Thank you.
and patience.
Good luck, Mr. Pastor. Thank you. Thank you. Christy Sharon Smith, 10B 723925.
Morning, Your Honor.
Mr. Cheney.
Oh, you're retained on this?
Yes, Judge. Stay,
Well,
please.
I hate to see you retained on this. You're Kaylee. What's she doing? Your name, ma'am?
Sheriff Burr.
She hasn't shown up here in how long? What's she gonna do? Is she going to plead on these?
Yes, but
You know, I'm not gonna be nice about this, right?
I understand, but
You plead guilty here, you absconded, you could get 93 days with credit for any time served, right? Did you sign an advice or rights form here today? You read it and understand it.
Yeah.
If you plead guilty, you'll be giving up all those rights. And there will not be a hearing. Do you understand that?
Yes.
I'm gonna need somebody in here, Sadie, from probation. All right. So I'm gonna ask you how you plead as to each one of these counts. If the count one that you failed to attend your scheduled visit on January 21 and 15, how do you plead? You failed to attend your visit on that day?
Yeah.
Is the count two that you failed to attend the victims impact panel? How do you plead?
Guilty.
You failed to attend the victims impact panel.
Yes.
Count three that you failed to submit the chemical testing as ordered on November 20 of 14. How do you plead?
Yep.
Did you fail to submit the testing on that day?
Yeah.
Anybody force you to plead guilty?
No.
Wait a minute. Something's wrong here.
We're kind of backed up in probation.
This is the wrong show cause.
what?
Looks like she was just in front of Judge Hessen, right?
Yeah, so it was pretty late.
Yeah, I know, but there was a different show cause. It looks like the one Judge Hessen arranged around. Maybe if you'll just give me a second here. I already adjudicated this show cause, it looks like. Now, this is the show cause. I made a mistake. They made the mistake, actually. They put the blue back from, this is what happens when cases become so old, for January 21 and 15. And as I look at it, I already adjudicated this case. The show cause she's here for are set forth in the show cause dated April 24th of 15. April 24th of 15. And count one is she failed to attend the court work program in March 21 of 15. Count two, she failed to refrain from consuming alcohol or drugs testing positive on March 16 of 15. That's count two. And it looks like that's it. those two counts. So I'm gonna have to ask her how she pleads on them. My apologies. If you plead on those, ma'am, I want you to understand, you could get 93 days since you've absconded. Do you understand that?
Yeah,
You understand all your rights?
yeah,
You understand you have two counts here, and that is count one, failure to attend the court work program on March the 21 of 15. How do you plead to that?
guilty,
Count two, you failed to refrain from consuming alcohol or drugs testing positive for cocaine. How do you plead?
guilty,
Did you test positive for cocaine on March 16 of 15?
yeah,
Did you miss the court work program on March 21 of 15?
yeah,
Anybody force you to plead guilty?
no,
Ms. Wild, your name?
Elizabeth lost probation.
I don't know what happened here. They gave me the wrong blueback. They gave me one from January 21 of 15.
One that I have in the file too, Judge.
That's wrong.
Okay.
I already adjudicated that. And if you look on the back of this, I sentenced her actually on that on February 18 of 25, and I was pretty kind to her. But then this is one dated April 24th of 15. All right. So I'm going to let Mr. Cayley here tell me whatever he'd like to say.
Your Honor, Ms. Smith knows that she absconded. She's had several tragedies in her life by way of explanation on excuse. Her daughter died a few years ago. She's been losing all three kids. Her husband died less than a year ago. She was working, she got hurt. She went back to work, she got hurt again. So she hasn't been working, she hasn't been driving. The last time she's had any adjudication with respect to any contact was in 2018. I believe she had an offense. Judge, she suffers from anxiety. Back then, I believe that was an OWI due to marijuana. She tested positive, obviously. She didn't complete the court work program. She posted the bond and the amount of the total fines and costs because she wasn't working, trying to raise these kids. And she got back from disability. She worked again, got hurt again, and she's applied for Social Security disability and workers' comp as well, Judge.
Can you figure out for me how many days she has credit coming?
I am not seeing any credit, Your Honor. I'm not seeing any proof of community service in an effort to give her credit. I am not seeing attendance on the court work program. I believe she was already given a day of credit by you for perhaps being in custody by the police at the time of her arrest. But I cannot offer any credit. The only positive I can offer in relation to her case is she attended the victims impact panel. That was it. Everything else she did not attend or she absconded from.
But she posted 1,020, right?
Yes, sir.
How much are we showing that she owes right now, Heather? Can you tell me?
She has a balance of 1,020.
All right, let me take a look at the record. So she had a larceny in 04. 19 was some kind of retail fraud, attempt retail fraud. 14 was impaired. I wish you would have come and talked to me. You know that? You can't do this. Do you have any other thoughts you want to have?
I don't, Your Honor. It's a 2010 case. Obviously, it
Well,
was
I'm not
dealt with years later, and we're past the 2 years for probation. Obviously, I leave it up to the discretion of the court.
Anything else you want to say, ma'am?
I'm sorry. I no, I'm with everything going on, my husband and I took care of everything. And looked at everything my husband said. As soon as he passed away in September, you know, I had,
He was sick for several years.
yeah, I was taking care of him and it's just, and I didn't drive, you know,
I just can't, condone this, but I'll give you credit that you haven't been in any more trouble. Probation's revoked. You're to pay costs of 1,020 and serve 93 days, credit 1 to 92. If you pay costs of 1,020, I'll suspend 65 of the 92 and you'll only have to serve 27. That's the best I'm going to do. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer. So sign over your bond. I'm sorry you're in custody, ma'am. Good luck. Thank you. Thanks, Mr. Gale.
Thank God.
Judge, I don't know if you want us to do it out here or if you want us to talk with you.
Well, let's address it. Mr. Beachy, would you come up and have a seat,
Come on,
please?
Mr. Beach.
Our next matter we're going to address is People versus, well, wait a minute, is the complainant here?
She's in the hallway. One. Move to the back, please. No, this is.
That's the attorney's side. Keep people.
But you're not gonna be close to my complainant.
Oh, good afternoon, Paul. We're happy to see you.
So I've got it just, I've talked to two of the people know what they want to do. I don't know if should I wait till I talk to the other two?
Yeah, go ahead. We've got another matter we're addressing, so, but when you get here, we'll be ready for you.
Okay.
Very good. He's back from the jail. He was. Anyway, let's restart. This is a final pretrial before jury trial in the matter of People versus John Mark Beachy. That's you, sir? Of course, I know who you are, but I have to identify you for the record. The file number, if I didn't say it, is 26-42SM. The matter alleges 2 counts of domestic violence, which occurred allegedly on January the 9th. The complaining witness in this case is Megan Sudbury. Prosecutor is represented by Angelique Campfield, and Mr. Tom Siver is here. We see a lot of Mr. Siver. Years past, but I haven't seen you in a long time till you got this matter. I know that you guys have been talking seriously back and forth. Mr. Siver, you're at the podium, so I'll defer to you. What's the status here?
Judge, I believe that we have a request of the court. We'd like to adjourn off the trial and adjourn the matter to a date later on. In the alternative, Mr. Beachy will begin a program recommended by the prosecutor. Prosecutor has indicated that if that program, if the person that runs it reports that Mr. Beachy is engaged in the program and making progress, then she will consider a different offer. If you'd like, we can put that different offer on the record.
No, I think
I wasn't sure.
we're all right. Well, maybe so. Domestic violence is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. There are 2 counts alleged here. There is a special type of probation that is available in domestic violence cases where the defendant could be placed on a probation, and if the defendant successfully completes the probation, the charge is taken off his record as a public record of conviction. And we can only do that if the prosecutor consents. And so that's often an issue sometimes in other types of cases, the court can do it on its own discretion. But in a domestic violence case, the court can only do a deferral if the prosecutor consents, under, I guess, the theory that they know more about it at that point than the court does. I don't have a terrible problem in adjourning this, but I don't want to go too far. There's another factor, the parties are aware of it. I don't know if you guys are. There's a landlord-tenant case tomorrow. Mr. Beachy is moving to terminate the tenancy of Miss Sudbury. This incident occurred on Mr. Beachy's house on Thompson Lane. And apparently, Miss Sudbury is living in another house across the lake from Mr. Beachy's house. Is that correct?
I have no clue.
Well, Mr. Beachy, do you own the other house on
No.
Resort Road?
No. That's where she went to after she left my house.
All right. I thought it was you doing the eviction. Maybe it's somebody else.
No, I'm doing the eviction.
All right. Do you own that house?
I own 55275 South Thompson Lane,
All right. Who owns the Resort Road house?
Jeff Glass.
And which house are you evicting her from?
My house.
All right, then I guess I didn't read the pleadings carefully enough. All right, so there's a no contact provision. So are you out of your own house?
I was out of my own house. She went to be at Jeff Glass's house on January 23rd, and she hasn't been back since. So then a week later, I moved back into my own house.
All right, so there was a period of time your children live at your house.
Yes, they do.
So where were they?
They were still at my house.
There's an odd set of facts. You're fine. Some of this I knew and some of it maybe I didn't. So there is a termination of tenancy case. There's no lease. And so at this point, tomorrow you'll be asking me to get the rest of her stuff out of your house. Is that correct?
Yes, sir.
All right. And we'll deal with that tomorrow. But it happens more than a little bit. In a domestic violence case, there's almost always a no contact provision. And on some occasions, several times a year, the owner of the house actually gets put out of their own house. But it doesn't prohibit them from pursuing a termination of tenancy action. The landlord-tenant judge and the criminal judge, sometimes those two things interact. I get all the PPOs that either have a domestic violence contingent or a landlord-tenant contingent. There is no PPO here, but
There is, Judge.
oh, is there a PPO? All right, well then.
The
maybe
PPO was
that's-
addressed by your.
By Mr. Pattison.
Yes, sir.
All right, well, we'll deal with the
Just give you a
landlord-tenant
full-
case separately.
Give you a full status on that. That was adjourned without date.
Okay.
Mainly because Judge said that he wasn't inclined to lift a PPO as long as there was a criminal case open. So we adjourned without date in order to
And-
resolve things in order.
Well, at this, it's less urgent since he's back in his own house. All right. So, Ms. Campfield, how long are we talking about adjourning this?
Your Honor, that is something that is really within the purview of I don't want to say the purview fully of the defense. The program that I was speaking with Mr. Seaver about for his client was something that I indicated I would consider, but I would not guarantee a change of my current offer. I would think that at least 4 sessions of that program would be enough for the instructor and therapist to notify me of whether there's sincere participation or just presence.
All right, well, at one time, domestic violence cases were supposed to be fast-tracked by the court. They were supposed to be resolved within 78 days of the arraignment. which wasn't always easy to do. So we already had an adjournment because of the medical issue. We lost a month. And it's not in anybody's interest to drag this out, but the defendant wants to avail himself of an opportunity to prove himself. I'm going to continue this for a final pretrial for April 30th. Snow will be melted by then, we hope. At 2 o'clock.
Your Honor, it may be a little bit unusual, but given the convoluted facts in the tenancy and pending eviction and things, may there be an amendment to the criminal order that none of the complainant's property be damaged or moved from the premises without the order of the court?
No, obviously it can't be damaged. This is a tenancy that needs to come to an end. There's no lease. She's not living in the house, not paying any rent, and the defendant wants some closure.
Judge,
I'm not going to use a criminal case to forestall a termination of tenancy case.
my clients informed me, I didn't know about the hearing for tomorrow, but my clients informed me that the property is no longer at the physical location.
All right, so it may be a fairly straightforward proceeding. If she's gone and her property is gone, there may not be much to fight about. The way it would work,
But I didn't even know there was a landlord tenant that had been filed.
the way it works now, a plaintiff serves a notice to quit on a tenant. Says, I want you to move. I want you to move by a certain date. In this case, 30 days. The defendant doesn't move, so the plaintiff files a termination of tenancy lawsuit, which is what this is. They want you to move. They have a hearing in front of the judge. Before COVID, generally, the judge would give you 10 days to move or you would be subject to being evicted. Now, we have to adjourn the matter at least 7 days for the defendant to have an opportunity to seek legal advice or emergency financial assistance to pay the rent. But in this case, he's not asking her to pay the rent, he's asking her to move. So tomorrow's hearing would be March 20th. It will be adjourned till March 27th. And the defendant would have 10 days from that day to vacate or be subject to being evicted if Mr. Beachy gets what he asked for. So this is a long process. Landlords are very frustrated, but if Mr. Beachy gets what he asked for, the defendant would have until April 7th to vacate or be subject to being evicted. But it sounds like she's already vacated and her stuff isn't there.
Your Honor,
Yes.
It's not a matter that the prosecution's involved in, but I'm being informed that she does not have her property. It has not been returned and she's not at the premises because she was locked out of the premises. I just want that on the record.
All right,
I
well,
have
there's
no knowledge of that other than my client told me that the property is not at the physical property anymore. That's all I know.
all right, well, maybe you can't do that. There's an anti-lockout statute.
I didn't do that, Your Honor.
All right, well, we'll hear that in the context of tomorrow's case. As a practical matter, I don't think she wants to move back there anyway. She just wants her stuff. And maybe we can accomplish some of that tomorrow.
But like mine, Your Honor, also, like she took my driver's license and all, and
This
All right, well, that's,
is not appropriate.
that's, I'm not sure what that is. This isn't a civil case for possession of property. But let me ask this. So you don't have your wallet or your driver's license?
And then I applied for a new one, and then that one ended up coming up missing out of the mail up as well.
Well, we don't know about that.
Which she did take.
Again, I don't want to get too much into the facts, but it's a huge pain in the neck not to have your wallet or your driver's license. I'm assuming you don't acknowledge that do you acknowledge that you have his wallet and driver's license?
No, I
All right, that was all right, well, that's not what's before the court, but, that's a divorce kind of stuff. Fortunately, I don't do that. Now, this isn't a divorce, but it's a breakup of a relationship of a year or so. Anyway, we'll sort out tomorrow about the property. What we're doing today is we're adjourning this about 6 weeks, to April 30th. The defendant, I assume, is going to start an anger management or domestic violence treatment class and participate sincerely, and we'll leave it at that. And the prosecutor may reconsider what their current offer is, which I don't know. Anyway, we'll hear more about that tomorrow. Nobody's under oath. Now, tomorrow's hearing is by Zoom. Either one of you are welcome to come live and in person. The hearing's at 9:30 tomorrow, I believe is the time. I'll be here. You can Zoom in or you can come here live to the courthouse. Either way, we'll address the landlord-tenant matter tomorrow. And the PPO matter apparently is on standby. So this matter is adjourned to April 30th at 2:00. Hopefully some progress can be made, and we'll address the property issues tomorrow in the landlord-tenant case. When you say wallet, did it include credit cards and all that sort of thing? All right, well, obviously she doesn't acknowledge it, but it's not what I'm here for. We may inquire further about it tomorrow. All right, you're free to go, and then we'll wait and let complainant go. Mr. Cyber, I'll see you on April 30th.
What's that, Judge?
I said, Mr. Cyber, I'll see you on April 30th.
Thank you, Judge. Have a good day. Good to see you.
All right, thank you.
Yep, I can send it.
Yes, the complaint was filed in February for the premises of South Thompson Lane, and her address is listed as Resort Road, which, as the crow flies, is probably about 300 yards away, but there's a lake in between the two. I misunderstood. I thought he was evicting her from the Resort Road. Notice to quit was served on February 11th, dated February 10th. On the owner, Megan was required to vacate property on 2/9/26. What the pleadings say. Notice to quit was served on 1/9. That's what he meant. She was supposed to move by February 9th.
On the record in the matter of the city of Wyandotte versus Miguel Velasquez, 251542.
Good morning, Your Honor. Tom Lane, here on behalf of Miguel Velasquez.
Thank you. And sir, counsel, your number, please.
P59757.
Man, we all work so hard for that number. I need to make sure it's on the record. Okay. And sir, your name for the record, please.
Miguel Velasquez.
Okay. And I understand that Mr. Bujacki is present and the court will allow Mr. Bujacki an opportunity to address the court as well. And counsel, I do apologize as well as Mr. Bujacki. It didn't occur to me that this was a different prosecutor at the time.
It didn't occur to me until I walked into the room and I realized this was a city case.
Yes. Okay. And so as far as the report and recommendation, did you have an opportunity to review that with your client?
Yes, Your Honor, there are no additions, deletions, or corrections. I guess the only minor correction, Your Honor, would be the restitution amount that I met with Mr. Bajacki. And if you want me to wait, Judge, to discuss that, then.
Okay, well, we can do that in just a moment. I did have a question though, under the general background information. It says he reported a mental health diagnosis or treatment. I'm not sure. Did you report a mental health diagnosis or treatment or did you not? And if you did, was there a diagnosis?
No.
No. Okay. So no mental health. Okay. All right. And when was your last use of marijuana, sir?
Prior to the first court date, Your Honor.
Okay. All right. So how are you doing not using it daily?
It's been a struggle, Your Honor.
Okay. Well, why do you use it daily?
It performs well at work, lift a lot of heavy ladders, and I have some back pains that I deal with a lot, and I feel like that just comforts in those moments.
Interesting, because you said your general health is good. You exercise regularly. You have no serious illnesses, diagnoses, or accidents in the past. And you're not under a primary doctor's care. So, does your employer know that you use marijuana daily to get through work? I mean, I don't know what kind of work you do, sir, with your employer, but
He has his own
when you
pain.
think that painting, you kind of need to make sure that you're focused and using the right colors or
He has his own painting company, Your Honor, that he's had. So he
oh,
works.
so I'm gonna guess his boss knows then.
Yes, sure.
Okay. All right. Well, sir, do you notice that you have a little bit more clarity?
I do, Your Honor.
There's something to be said about that.
I also reached out to my primary to get on some medication for my ADD. I'm just going through that process as well.
Okay.
Trying to figure out what works best for me.
Okay. All right. And so, counsel, did you want to address the court first for any allocution, or do you want me to hear from the victim first?
Oh, I'd be happy to.
Oh.
To go ahead, Your Honor.
Okay.
Your Honor, as you can see, Mr. Velasquez is 22 years old, has no prior convictions. I know he regrets the poor decision he made, or we've had a number of discussions with my client and his mother, Your Honor. And he takes this very seriously. Graduated from Lincoln Park High School, works full-time as we just discussed. He has a 4-year-old son that he has joint custody of. I would share with Your Honor, Mr. Velasquez completed an anger management course, had a certificate of completion, if I may approach.
Okay.
And Your Honor, I do see that as a recommendation. And Mr. Velasquez is aware, Your Honor, that he may need to do additional. He just wanted to get a head start on it. He and his mother thought it would be a good idea.
Okay. Before you continue, counsel, Mr. Velasquez, tell me something you've learned in your anger management class. And of course, counsel, you're correct. 4 hours is a start.
Yes.
Yes.
There was a lot I actually learned, Your Honor. It's really just thinking before doing anything, why I'm feeling like this, any other possible outcomes that could happen with the anger. I've actually have a journal at home that I started during the intermittent court that I've just logged. It was a lot. It was only 16 pages. I should have brought my journal.
Well, that's good. And so, are you still with the girl that was in common, apparently?
Yes, Your Honor.
Okay. And you do understand, sir, right, that territorial and people don't necessarily go well together, right?
Respect.
And that you have to have some trust in people, right?
Yes.
Okay. And counsel, you may proceed.
Your Your Honor, just lastly, I'm confident that he will do everything that you ask of him. As I stated, Judge, I really believe he does take this very seriously, and I'm confident that nothing like this is going to happen again. I think he takes, I'm confident he takes this very seriously. And I would respectfully ask that Your Honor follow the recommendation from probation. Should I state right now, Judge, that the amount that we agreed on? I did, as I stated, Your Honor, met with Mr. Bajaki in the hallway. Probation had forwarded most of the medical documentation that I already had. He supplied a little additional, and there is a slight change, Your Honor, that Mr. Bajaki and I agree on. The amount in the pre-sentence report was $1,360.66. The amount that we have agreed on, Your Honor, is $1,410.66.
Okay.
And Your Honor, with regard to the restitution, of course, I spoke with Mr. Velasquez regarding money and when can we have that paid off. And if it's okay with Your Honor, he can do a minimum of $100 a week paying to the court, and as well as the restitution. But he can do at least $100 a week if that's okay with Your Honor.
Is that only the restitution amount? And then in addition to the fines and costs?
Oh, that's fine. I'm glad to be clear. It's just for the restitution. He can do a minimum of $100 a week.
Okay, so 400 per month.
Yes, Your Honor.
Okay. All right. Okay.
That's all I have, Your Honor.
All right, thank you. I'm going to have you just step aside for a moment, Mr. Bajaki, if you'd like to step forward, sir.
Yes, go ahead. You can have a seat right there.
Hi, and sir, your name for the record, please.
Bryce Bajaki.
Okay, are you picking him up?
No.
Okay, I need you to speak a little bit more loudly. If you can please keep your hands out of your pockets and then spell your first and last names also, please, okay?
Bryce Bajaki, BRYCEBJAKI.
AKI, there's OC, there's OC. Oh. And are you chewing gum? Okay, there's a tissue right on the bottom of the podium. Underneath, there's a shelf. Okay. That's all right. Okay. And so, sir, thank you very much for coming in today.
I apologize for the way that addressed for court today.
That's
I haven't worked right.
Okay. And so what would you, I appreciate you addressing that. And what would you like the court to know, sir?
I don't have much to say on the fact. Everything's already, you know everything. I know everything.
Well, no, I don't know everything. I only know what's in the report.
You know,
that's all that I know.
So what exactly is it?
I know the least amount out of all of you.
Just seeking a restitution for an altercation at a bar. Really.
Right. And then you were knocked unconscious. I know that part.
Yeah. That I was
very above the legal limit at the bar.
just really unaware of my surroundings, got taken advantage of, got grabbed. I don't even know what happened, to be honest with you. That's how kind of out of scene I was. I was not so like to defend myself in any shape or form.
Okay. All right. And so, sir, you had medical bills as well, correct?
Yes, ma'am.
All right. And you're in agreement with the amount of $1,410.66?
Yeah, of course.
And what did you have? Some head trauma? What was the?
I got a scar right here I want to say my face was, like this was bruised. The whole side of my face was bruised for a good month. I had to go to work like that, looking like that. It was nice. You say I had 2 or 3 fractured ribs. I don't really know how that happened. I get cracked, something like that. That's what the CAT scan said.
Did you get a chair on your way down? Do you know?
There's a really hard wall, hard floor. It's like
okay.
concrete, so I don't know what happened in between. If I got kicked or something, I really know.
Okay.
I can't recall it. So I'm sorry.
That's all right. Okay. Anything else you'd like the court to know?
No, that's all.
Okay. Thank you very much for coming.
Thank you for your time. I appreciate it.
You're welcome. All right. Counsel? All right. Anything else, Mr. Velasquez, you'd like the court to know?
I'd like to start off by apologizing to the court and to you, Your Honor, and also Mr. Bujaki. It was very out of character for me, and I do take this matter very serious, and it will not happen again.
Okay. All right. Well, I'm glad to hear that you apologize to Mr. Kajaki. It does appear as though you have some remorse for that. Sir, just a little bit of life lesson information, right? You're 22, correct? And at the scene, at least, the information that I have is that you felt disrespected, so you swung on Mr. Kajaki. Spoiler alert, you're going to feel disrespected a lot during your lifetime. I'm certainly hoping, sir, that some of these conditions this court's going to put forth are going to be helpful so that you do not react in the same manner every time you're disrespected.
Sure.
Right? Because you don't know what somebody else may have on them, or you just don't know. And Mr. Langtock can also tell you, right? Doesn't matter what profession you're in, people are disrespectful to you. Whether you're in service, right? Painting, which is a service, medical, legal, whatever it may be, people are disrespectful. And so whether Mr. Bujaki was in fact disrespectful or not, he can't remember, right? And or whether or not you just felt disrespected because he was talking to your girl who is her own person. Clearly, this is not the way to respond.
I understand.
Right. And I'm hoping that in the continued courses for anger management that you're going to learn some other coping skills for that. Okay. Based upon all that, after hearing from Mr. Langtock, hearing from Mr. Velasquez, reviewing the report, the recommendation, hearing from Mr. Bujaki, the court does find that there's reasonable grounds to depart from MCL 769.5. The court finds the following sentence to be in the best interest of justice, to be reasonable and proportionate to the circumstances surrounding Mr. Velasquez and the legislative guidelines. The court's going to order 12 months probation. You're HIDA eligible. You're also eligible for early discharge with a hearing. You are not to violate any criminal law of any unit of government. You're not to leave the state without the consent of the court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, writing, or virtually. You're to notify your probation officer immediately of any change in address or employment status. You're not to use any alcohol or drugs unless prescribed. You'll be subjected to random testing. The rehabilitative goal for that condition is so you can, the court can monitor your progress in maintaining abstinence and sobriety. The GPS teller that you currently have on may be removed. You are not to have any contact with Mr. Bujaki. That's phone contact, text message, email, social media, third party, anything of the like. You're not to return to Captain's Bar. You're not to return to Mr. Bujaki's place of employment or his residence, if you even know where that's at. You're not to possess any firearms or weapons. Do you have any of those, sir?
I returned mine to you.
Oh, no, not to me. I don't have it.
As part of his bond, Your Honor, Raymond, you wanted him to turn them into the police, which he.
Okay, so Wyandotte Police Department has those for safekeeping. All right, that's going to continue until your probation is completed, okay? The court's going to also order, sir, you are to complete an 8-week anger management class. And as I did indicate, the 4-hour class was a good start. The rehabilitative goal for that condition, obviously, I mean, I think that's obvious, but I have to state it anyway, is so that you can further have, so that you can have additional assistance in learning how to prepare you for upsetting situations and navigate those feelings of frustration in a more appropriate fashion. And then as it's been agreed upon, restitution, the amount of $1,410.66. Do you have any questions regarding any of those conditions?
Maybe the 8-week program. like, so I did the 4 hours. What is 8 week equivalent? How, we'll talk about it. Okay.
Yes, you'll get more information and more details from probation. There's multiple platforms and groups or agencies that do offer that.
Okay.
So I'm sure some, if you need online, I'm sure some have an online component. Okay. The court's going to order a $300 fine, $100 screening assessment fee, supervision oversight fee of $600. That's $50 a month at 12 months. Since you're eligible for early discharge, albeit with a hearing, up to half of that could be waived. Cost of prosecution, $300. Crime victim assessment fee of $75. Justice system assessment fee of $50. So that is $1,425 plus the restitution of $1,410.66, which I'm going to indicate that's to be paid at a rate of $400 per month based on what you've indicated. And as to the $1,425, so you did post a bond, which brings that down then to $925. Subtracting out $300, it leaves you with a balance of $625 on your fines and costs. Do you have that to pay today?
I can pay it at the end of the month. I can pay
Okay.
500 at the end of the month.
Okay, that's fine. All right. Okay. All right. And as I did indicate, sir, you are eligible with a hearing. So you can request that hearing only after all the following have occurred. You've completed at least half of your original term of probation. All probation requirements have been completed. You've had at least 3 months without any violations, and all monies have been either paid in full or you've made a good faith effort toward making full payment. You understand all of that, sir?
Yes, Your Honor.
Okay. Any questions?
Maybe just about the GPS, Heather. Do I get paperwork to walk in there?
When you go over to probation, you're going to get the information about all that as well. Okay. All right. Anything else?
No, Your Honor, thank you.
All right. Thank you very much, sir. I'm going to have you go over to probation and then you'll get set up with all of your next steps. Okay.
Thank you, Chuck.
Good luck to you. Thank you. You as well. Thank you. Let's go on the record in the matter of the state of Michigan versus DeJuan Benford, 2676.
Good morning, Carly Kavanaugh, P86281 on behalf of Mr. DeJuan Benford. Mr. Benford, please state your name.
All right, thank you. And today is the date scheduled for a bond violation. It's alleging that Mr. Benford did not appear for testing as ordered by this court. This court ordered Mr. Benford to not to possess or consume any alcohol or drugs unless prescribed, to participate in random testing, and that upon release from custody, you were to report to probation the next business day to set up testing. And this was all dated January 15th. It shows that a bond was posted for you on January 15th as well. And you were to go to probation to register for testing, which tells me that you registered for testing because then you didn't show on January 18th, you didn't show February 11th, and you didn't show February 14th. And then on March 1st, when you appeared, you tested positive for alcohol. So those are the 4 violations of bond violations for your client, counsel. Did you have an opportunity to speak to your client?
Yes, I have, Your Honor. My client would like to take responsibility and plead guilty to those violations today, Your Honor.
Sir, please raise your right hand. Do you solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right. And you heard those allegations, sir. As to those allegations, how do you plead?
Guilty.
And you've gone over your advice of rights with your attorney, correct?
Yes.
And you understand all of those rights.
Yes.
You also understand by entering into a plea that you'll be waiving some of those rights.
Yes.
You also understand, sir, the possible penalty as a result of your plea.
Yes.
I could revoke your bond. I could have you in custody until your next hearing. I could order a fine or some other conditions, the combination of all of that. Do you understand that?
Yes.
Knowing all that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Thank you. And counsel, if you can please voir dire your client.
Yes, Your Honor. Mr. Benford, you were aware that you were to randomly test with probation for your bond, correct?
Yes.
Okay, and on January 18th of 2026, you did not appear for that testing, is that correct?
Yes.
And the same goes for February 11th of 2026. You also did not appear for testing as required that day?
Yes.
Okay, and the same goes for February 14th. You also did not attend that day for testing as required, is that correct?
Yes.
Okay, and on March 1st of 2026, you did attend and they collected your testing at 8:02 a.m. and that returned positive for alcohol, is that correct?
Yes.
Okay, and you indicated to myself that you had used a small amount of alcohol the night before March 1st, is that correct?
Yes.
Okay, satisfied if the court is, Your Honor.
The court is satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the bond violations. And counsel?
Thank you, Your Honor. I do have a little bit of explanation for his reasons not to appear at the court, Your Honor. On January 18th, that date was a snowstorm. I mean, understand that's not a legal excuse to not come to your testing, Your Honor, but my client does live quite far from the court. So that was his reasoning of not attending that day, Your Honor. On February 11th, my client actually was incarcerated. He was taking care of his bench warrants for traffic matters that this court is already aware of. And he was incarcerated for one night when he had to turn himself in to take care of one of the warrants in Farmington Hills. So the February 11th date, that was his reason for not appearing that day, Your Honor. On February 14th, he was at the doctor's with his mother as she had torn her Achilles. Again, not a legal excuse not to come to probation for testing, Your Honor, but that is my client's explanation of where he was and why he was not at the testing facility, Your Honor. And then for the positive screen, my client did take responsibility that the night before he did take one shot at work, I believe he was at, or just after work. So, Your Honor, he is taking responsibility today. I do want to indicate to this court, we were just here, I think last week, for sentencing, and we held over sentencing. That way I could look into the sobriety courts and he could resolve some more warrants. So since last Thursday, my client has contacted all of the courts that he has traffic warrants in, and he's been taking care of those. And I've been in contact getting some information for sobriety courts. So, Your Honor, I am asking the court today maybe to hold off the sentencing on the probation violation and have it adjourned to the same date as the sentencing date for his case, so we could see what direction Mr. Benford moves with sobriety court possibly being an option, as I do think, obviously, this is an issue for Mr. Benford. If not, Your Honor, I do ask the court to offer fines. I ask the court not to incarcerate my client at this time, just so I have the opportunity to be working with him to possibly see if one of these sobriety courts he can be screened for, and we can return back to the court. I believe it's April 2nd we're due.
Yes, it is April 2nd. The reason why this is scheduled for today is because that was quite a bit of a ways away from when these violations occurred. So I didn't think that it would be prudent nor helpful if we waited until then for all that. So, sir, where is it you're testing?
It's on Grand River. I want to stay in Wyoming, and I stay in Hazel Park on 9 Mile Decline.
Right. So I just wanted to confirm that you were testing out your way, because typically the testing, one of the testing facilities that is utilized by the court is this way, which is much more of a distance than where you're currently testing. Sir, If I'm testing you right now, what's in your system?
Absolutely nothing.
Nothing at all.
Nothing.
And so there was a snowstorm on January 18th. I mean, I don't know, there was many snowstorms this winter. And so, sir, how did that prevent you from getting to testing?
The day before, the 18th was a Sunday and the 17th was a Saturday, so they're only open from 6:30 to 9 a.m. And it was very hard for me to get there that Saturday morning, and the very next day I had to repeat the same process, not getting on a ride in time before it closed.
Okay. Sir, knowing that you cannot drive and that one of the conditions of bond is for you to participate in random testing, you should have 5 options to get you somewhere. 5. Plan A, B, C, D, E, right?
Yes.
You should have those all lined up ahead of time, not waiting till the morning of to find. I know that you don't know until the morning of that you have to test, but just have your plan A, B, C, D, and E ready to go in the event you have to test. Preparedness, sir, planning ahead is what's going to help you be successful. So tell me, okay, so you were in custody in Farmington Hills on the other date.
Yes.
Okay. And you provided proof of that to your attorney?
I didn't provide proof, but I can, if it's applicable, I have paperwork and everything I need.
Okay.
And that case is also open, so.
Very good.
I on my own did speak to the Farmington Hills Court, Your Honor, and confirmed.
Okay, thank you. And then, sir, you were with your mom at the doctor's.
Yes.
What time was her appointment?
She tore her Achilles that
Hold on.
day.
Nope, that wasn't my question. What time was her appointment?
She didn't have an appointment today.
Okay.
I took her to the doctor. I went with her to the doctor. She tore her Achilles.
Okay. What time did you go?
It was around 7:30, 8:30.
In the morning. Great. Then you had time in the evening to go test.
That was a weekend day, February 14th. I believe was the same day. So they're not open in the afternoon.
Oh, no, it was a Saturday.
Saturday. So they're not open in the evening.
Okay. So at any point, sir, did you contact into anybody letting them know of the certain issues that were occurring as to why you couldn't go test? Did you email into the court here?
I wasn't fully aware of who I should contact, but now I'm very aware that I should contact the court.
Okay. And sir, you're not allowed to drive. So how'd you get your mom to the doctor for her torn Achilles?
I rode with her with my sister.
So then you could have had your sister drop your mom off and take you to do your testing and go back to get your mom.
Yes, that could have been possible.
Correct. Tell me about your this one shot you took, which I think it was more than one shot based upon your levels, but in any event.
At work, we were allowed one shift shot, and I wasn't fully. I believe we did state it in my bond conditions when we were spoken of Zoom, but I don't know if you maybe remember or not. But it was kind of hard for us to, not us to communicate, but it was the sound was very, very, and some of the officers even stated that they couldn't hear some of the things we were saying. And when you gave me my conditions, I also did believe that I was supposed to be untethered, which I guess I was not something that you stated, but I did not receive my bond conditions. So I was unsure what exactly my conditions were, but I did take one shot. We're allowed one shift shot.
So when you didn't get any paperwork upon your release?
No.
Nothing, not a pretrial release form to give you your next court date, not a copy of your bond conditions?
No, I did receive my bond receipt, but I didn't get my bond conditions and I didn't get my next court date until it came in the mail.
All right. So let me ask this question, sir. When bond was posted, were you still at the Wyandotte Police Department jail or were you at Wayne County Jail?
I was in Wyandotte.
And the person that posted the bond for you didn't get a copy of your paperwork either?
No.
Okay.
She was also the one who came pick me up, took me home, and said.
Okay. Well, that's an issue that we're going to have to figure out how that gets resolved. Okay, sir. What I'm going to do is I'm going to hold off the sentencing. I'm going to put that in abeyance for this point, at this point on your bond violations to April 2nd. And how are you doing with any screenings with treatment courts?
I've gotten the information, Your Honor, so he will be screening this coming week.
Do you have a copy of your bond conditions now, sir?
No, I do not. And I ask you to please receive one today before I leave.
Absolutely. We're going to make sure that happens. And you're correct. There are sometimes it's difficult to hear in the jail there. Okay, well, okay. You can give them a copy of this, but if you can also give them a copy of the back sheet, the back one, if you can do a 1-page double-sided copy or what have you. Okay, sir, just have a seat and somebody will be with you shortly to give you a copy of that, okay?
Okay.
Bond and conditions are continued. Continue to test, sir.
Yes, ma'am.
All right, we're on the record in the matter of the city of Riverview versus Edmund Moss, 251564, in the state of Michigan versus Edmund Moss, 251225. Good morning.
Morning, Your Honor, John Goldberg, P 30758. On behalf of Mr. Moss. Mr. Miller. Just put your name on that.
Edmund Moss.
All right, thank you. Today is the date scheduled for probation violation hearing. It's alleged that Mr. Moss had alleged contact with the victim, Mr. Calipari, on March 2nd of this year. And counsel?
Your Honor, I've had an opportunity to review the probation violations. They're on two separate matters, but they're the same identical violation. I've also discussed with Mr. Moss's breaks in this particular matter, spoken in length, Mr. Moss, regarding this incident. So, based on all of that and what the recommendation at this time, we guilty to that position.
All right. Is Mr. Calipari here? No. Okay. Sir, please raise your right hand. Do you solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
So help me God, I do.
All right. And you heard the plea that was placed on the record with the allegations, correct, sir?
Correct.
As to those allegations, how do you plead?
Guilty.
You've gone over your advice of rights for probation violation purposes with your attorney, correct?
Correct.
And you understand all of those rights.
Correct.
You also understand by entering into a plea that you'll be waiving some of those rights.
Correct.
And has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No,
And you understand the possible penalty as a result of your plea.
I do.
And the recommendation in this matter is for you to continue probation and complete all of the previously ordered conditions, correct? All right, counsel, if you can please order your client.
Mr. Moss, you were placed on probation to this court for these two separate cases. Is that correct?
That's correct.
And part of those terms and conditions of probation are that we're not to have any harassing, intimidating, or basically any contact whatsoever with Mr. Calipari. Is that correct?
And that's correct. And that's what I've tried to do.
Yes. Is that correct?
Correct.
And on the 2nd of March, did such contact occur?
Unfortunately, yes.
Okay. And you appeared at the Riverview Police Department. Is that correct?
On that day?
On that day.
Yes, afterwards.
And afterwards. And if they wish to make, you actually admitted to the Riverview police officers that you knew what occurred based on the report that you wanted to make wasn't. Is that correct?
That's correct. However, I did make a report.
We haven't gotten that far.
Okay.
Okay. And you did make a report against Mr. Calipari as well. Is that correct?
That's correct.
Bench satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the probation violation, indicate, non-technical violation 1 will enter. And counsel?
Your Honor, that is the recommendation you do.
So, Mr. Moss, I found it interesting when I was told that Mr. Calipari didn't want to, was because Mr. Calipari wasn't technically the, Mr. Calipari didn't contact into probation regarding the alleged violation or regarding the violation. It was put forth by the Riverview Police Department. And Mr. Calipari, apparently communicated with probation after being notified of the probation violation, which was proper protocol and procedure, that he didn't really want to come in or what have you. Well, now reviewing the report, I see why, because apparently it's alleged that he punched Mr. Moss, right? So knowing the history between these two individuals, without even reviewing what this report was, I found that very odd. And now I see why, okay? But I also, in this report, it states that Mr. Moss, when he came home from a Riverview City Council meeting, decided it was appropriate to start honking his horn to aggravate Mr. Calipari. I dare to ask Mr. Moss, why, pray tell, do you find that that's appropriate, that you need to do that?
I did it as payback for what was started against you. I tried to avoid him. He has continued to try to talk to me and look in my direction, which are all violations of your court order. I have contacted the prosecutor's office to no avail on it. And frankly, when he struck me, I'm glad I went. I did go to the police department for it because it could have been far worse than that.
Okay.
And you know,
and sir, you're correct. He should not be striking you. And I don't know if there's charges coming from that. I have no idea, right? Because you made a report. So I presume that there's going to be something. Right. Sir, but that doesn't answer my question.
Okay.
What answered my question was you saying that it was payback. Well, at some point, one of you two has to stop this nonsense because that's what it is. It's nonsense. Mr. Calipari may be upset that you are living in his family home that he didn't want to sell, whatever it may be, but he has to get over it. Okay. And you have to get over wanting to have payback or get even because he has, 3 more times he's looked at you than you've been able to, equalize that. All right. Just stop. Stop. I mean, what you want to honk the horn to aggravate him? For what purpose? Because look what happened. Look what happened. It serves zero purpose. Did you feel better after you honked the horn?
I didn't have time to process it between that and him standing immediately outside my vehicle as soon as they pulled in my driveway.
Okay, well, what did you think was going to happen, sir, when you honked your horn to aggravate him?
I don't know. I don't know his mindset anymore. And frankly, after striking me, I'm very concerned about my safety, frankly, because now he's punching me and he's getting away with it. Before it was assaulting me, before that, it was raising his fist to me years before that. What's it going to be next? A knife, a gun? I mean, how far is this going to go? And that, I've not struck him. I've not pulled a weapon out on him. I don't intend to. And I already promised Lieutenant Beamish years ago, and you may not have knowledge of this, that I would not hit him. And I think that's part of probably what stopped me on that note, because I sure as heck wanted to, and I'll admit it.
Well, sir.
But I did not. I went to the police station instead, only to have him follow me, shining the brights on me until somehow he got detained at sibling delayed so I could make it to the police station safely. I still stand by my decision every time, and then I've been over it 100 times in my mind at least, and I came to the same conclusion that I did every time.
Okay, well, sir, I'm glad that you made good on your promise to not hit Mr. Calipari. Can you make a promise to yourself in this court that you're not going to try to do something intentionally to aggravate Mr. Calipari?
So long as it's mutual, I'm
No,
fine
no,
with that.
no. I'm asking you. Mr. Calipari is not here right now.
Right.
So I'm asking you if you can make that promise.
Well, it'd be dependent on what I said.
No.
The question is.
No. Hold on, Council. My question, sir, is can you make a promise to yourself and to this court that you are not going to intentionally aggravate Mr. Calipari moving forward?
I try. But I don't know what he's likely to do, so I can't, I would be dishonest to say that I can really make promises.
Okay.
I can say this, if he leaves me alone, I'll be more than happy to leave him alone, and that's what I've done all along.
Okay, well, sir, your statement that you came home from the council meeting and you were honking your horn to aggravate Mr. Calipari. Okay, so that type of behavior is what I'm asking you to make that promise on. Not necessarily if he's approaching your car with his fist raised, right? I'm asking about this. There's not a tit for tat that has to go on, right? There's not a tally mark that there has to be an equal number of tally marks of aggravating behavior. That it doesn't even have, that's not even a thing. It doesn't have to be a thing. So that's what I was asking you, sir, about the promise.
I can try. That's the best I'm gonna say, because I rarely make promises, and I'm not gonna make a promise if I'm not certain I'm gonna keep it. That'd be true to anybody, so I'll leave it at that.
Okay. All right, the court's going to adopt the recommendation.
Thank you very much, Ryan.
And you could probably contact the police department to find out what's happening with the matter with the assault by Mr. Calipari.
I'm gonna be able to do that when I'm not allowed to contact the police.
You can, you can contact.
You can.
I wanted that as your process.
No, you're correct. No, you're correct. I'm glad that you didn't do that. I'm going to say you can do that by way of your attorney, Mr. Gopal, can contact him just to find out what the status is. Okay, so that way there's not.
That'd be fine, Your Honor. I have to go and get some discovery review.
Okay.
So
All right,
track that down. Thank you very much, Your Honor.
thank you. Have a good day.
Should you go around probation or? That's just.
You can, just in case there's anything you have to do.
Okay. Yeah, for sure.
Yes, let's go off the record. Can you hit mute on that for me, please?
That's right. He's already ruined his opportunity to be calling the police for just any old thing, because he calls it for everything. We had a little special showing off videos directly from his very own channel, which Rhonda has very nicely linked in the chat there, showing off some of his pointless calls to the Riverview Police Department. Mr. Moss is a nightmare. And I just want to point it out for those of you who aren't aware. He previously ran for mayor of Riverview. He did not win. I don't even think he came close to winning, but he did try, and he goes to every single community meeting. He takes his camera with him. He has things to say. They kicked him out. He gets mad about it. The puppy's on the couch. You know, he's been a whole thing. But you know, we've had quite a journey tonight, starting off with the 94-year-old groper, and moving into all of the crazy stuff that we saw with Judge Dad, and the DV hearing with Judge Middleton that's turning into a some sort of weird eviction hearing possibly tomorrow. We will possibly be seeing more of that tomorrow evening. So if you don't know already, we do these things every single night, same Wolf time, same Wolf channel, and that's about 8 p.m. Central Time, 9 p.m. Eastern, every single night of the week, where we review court content of the day. These are cases that all happened today. On Saturday, we'll be doing a weekend case review where we review a bunch of cases that I didn't have time to get into this show right here. So if you're interested in some more court content, you know exactly what to do. Like, comment, subscribe, all that type of good stuff. I am your humble Lone Wolf Usul. I am your curator for these here court content compilations. I am your host here at the Court Gallery. Ladies and gentlemen, for now, I am out. And I do want to say a very humble thank you to all of my favorite friends in the chat. Math Girl, Felix, I am Low, Mama Wolfie, I'm talking to you, Steven, Marty, Word, Eileen, I'm so happy you got some rest this evening. And Rhonda, you need to get feeling better. I don't know. I expect more. Nah, I'm kidding. You're great. Cat, I'm scrolling up. Everybody just watch me scroll up. VM Cougar, love ya. Kieran, love ya. Love all you people. Francis, great to see ya. Great to see all of my friends out there. Thank you, Law Nerds Unite. Thank you, Law Talk with Mike. Thank you, Hutch. Thank you, all my great friends, Colin, and everybody out there in the court watching community. I'll see you next time. All right, hold on, Steven. I'll give you some reasons to pull those quitters back up. Give me just a second. I'll think of something. It's an important thing to point out that those who know how to dance can be considered insane by those who cannot hear the music. Have a great night.